All right, go ahead.
All right, roll cam.
All right, welcome to another edition of Justice for Y'all. I'm here as always with Andrew Bowen and Stephen Morrison, and today we're going to be talking about a very specific area of federal law called the or called Qui Tam actions, which is the False Claims Act. In other words, whistleblower actions. But before we get that, how y'all doing?
I'm doing great. We're drinking right now. Have a little sip on a Friday afternoon.
Lubricates the mind, yes.
Four Roses single barrel bourbon, distilled by the Four Roses Distillery in Kentucky, and it is an excellent bourbon.
This is
Just had my first sip. It really is good.
It is good. This one has a particular memory for me. I drank it with some partners at one of my old firm after work, and it was an early bonding experience. So it's to me, Four Roses brings lawyers together, and that is copyrighted.
Four Roses might have issue with that, but yeah, sure.
Come at me.
Yeah.
This is the single barrel, which is excellent. A step up from this is the small batch.
Yeah, that's really
had
good.
that, but it's just a great sipping whiskey.
Well, we'll have to have that in another edition.
All right, Four Roses bourbon.
There you go.
It's also at least second false fall, maybe even the real fall.
That's right. That's right. It was 55 degrees this morning when I woke up.
It's really nice.
It was really good. Yeah.
All three of us have invested at some point.
That's right. In other words, for those who aren't familiar with investment, we're wearing vests to work today. Well, over the week we did. Yeah, not all today.
Well, it's also Savannah, and you
Doesn't
have to
take
take
much.
the vest off probably by 11.
Right. Yeah, it's 98 degrees now, but
Right.
this morning it was great. Yeah, it's good southern weather. I saw on Tuesday it's going to be a high of 86 and a low of 55. Yeah, it's easy to dress for. Did you all see that the Aurora Borealis was visible in Georgia last night?
I heard that. I did not see it.
I didn't see it either. Second time in the last few months.
Right.
I saw this headline. I don't know if it's true, but some people were saying that what we saw was not the Aurora Borealis. It was some kind of afterglow from some power plant down here. So you're always going to have a contrarian as far as I'm concerned. People saw it, and they should be happy about it. Don't take that away from us down here.
So did you talk to or hear from anyone who actually saw it with their naked eyes?
No, I just saw it on the news. I mean, there was somebody quoted on there, but I didn't.
Because when
I'm not sure you can see in Savannah or not. This was in Atlanta.
a few months ago, it was supposedly visible in Savannah.
Yeah.
And I could not see it. But apparently, if you took a picture of the sky with your phone, it would show up on the photograph, even though you couldn't see it with the naked eye.
Really?
Yeah.
So to that point, in Savannah, there's a local weather station. It's like a hobbyist weather station on one of the creeks around here. Took a photo with a long exposure. Apparently there's like a 6-second exposure, but sure enough, the sky was Aurora Borealis.
In Atlanta last night, it could have just been mistaken for that, chemical plant explosion left over.
Right.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the Southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
Yeah.
Sparks a lot of class actions, a race to the courthouse.
Well, I think we should talk about that on another episode.
That's right. Stay tuned.
What else going on? Got the Dogs' victory against Auburn last week. Bounced back from the loss against Alabama.
Overshadowed by the upset. What upset me that Vanderbilt, who was always I don't need to go to that game. They were the one who made the upset. I'm really happy for you, Vanderbilt. It's wonderful. But I don't know how the Commodores did it and we didn't.
Well, I don't know. But they played a heck of a game, and they did. The thing is, they beat them, too. It wasn't some fluke. I mean, they just
Hey, it's
had them the whole game.
The Diego Pavia show. It was a little kid, that kid's special.
Yeah, he is.
I saw something, some people trying to justify it in the lineup and things like that. But I really think what actually happened is Alabama's deal with the devil expired when Nick Saban came, and they were not able to renew it in time,
Right.
To before the fourth quarter was over.
Well, the week before was the Georgia game in Alabama. Alabama played a great game that game, and probably had a little bit of a hangover going on the road to Vanderbilt, a game that they probably felt like they should win.
Yeah.
So, it's a classic
Perfect
trap.
storm.
Have y'all seen those clips of Nick Saban from a few weeks ago? Like it wasn't on game day, but it was like a pre-game day interview, and he said, everywhere in the SEC is hard to play except for Vanderbilt.
Oh, that's good.
It's been troll bait on the internet all week.
But, speaking of Nick Saban, that sort of trap after a really big emotional game, then going on the road to a quote lesser opponent, was something that Nick Saban typically was able to avoid during his tenure at Alabama.
Yeah.
So
I mean, it's a
that's
scheduling matter.
well, not a scheduling
No,
matter.
he just
I'm just
knew how
saying
to get people.
Oh, I see.
his team didn't have that letdown after a game like the Georgia-Alabama
Right.
game the week before. So
Yeah,
that's
they stayed really even. They didn't really ride the highs and emotional lows of the
so
season.
that may be the first indication that Nick Saban is gone.
I think it's pretty safe to say that is.
It's never safe. He's always there.
He's been fun watching game day though.
Yeah, I think he's found his stride.
Yeah.
I like it better than Geico commercials.
Oh God.
Yeah.
And presidential commercials.
And I'm so ready for the
That's
election.
I'll tell you, yeah,
Less than
seriously.
a month.
Living in Georgia right now,
Bring it on.
battleground state, it's just inundated with it everywhere.
Yeah.
So tired of it.
Early voting starts October 15th in Georgia.
That's right.
Oh, is that right? Okay. That's coming up.
Yes,
Time-
it is.
Time to. I think it's too late to register. I think that's over. So.
Yeah, there was a court case about Hurricane Helene
Mhm.
trying to extend the time to register to vote, and the judge said, nope, it's over.
No, it's. I think there's been pretty good job across the board of folks being reminded about the opportunity to register and things. I've seen it a lot more in different channels this cycle, I think, than I have in others.
Yeah.
It's on your Instagram,
Yeah.
sorts of my emails. The guy that's walk out my door pops up Halloween decorations.
Halloween decorations may be the most accurate thing for this election.
Yeah, seriously. Yeah, we had some verdicts in Chatham County, at least one wrongful death
Yeah.
verdict this week, a $3.5 million verdict. Don't know the full details of that case, but that was breaking.
It was a police chase that
That's right.
and somebody not involved in the chase got killed.
Yeah, it was sounds like
Bystander.
a bystander was hit. Those are challenging cases.
They are.
Yeah. Well, what else do we have on the docket for today?
Well, we're talking a little bit about false claims.
False claims. Qui Tam.
Qui Tam.
Qui Tam.
Well,
Key.
agree to disagree.
That was just me.
Yeah, where's the button?
Yeah, that because he's in control of the buttons.
He's in control of the buttons.
Yeah,
He can't do his own joke.
that's the
Yeah.
flaw. Yeah, so Qui Tam is a shortened form of the longer Latin phrase. I think it may be the longest Latin phrase that I've learned in my legal practice, and the full one is Qui Tam pro rege quam pro se ipso in hoc parte sequitur.
Really rolls off the tongue.
It really does, yeah. Qui Tam pro domine rege quam pro se ipso. And that's nice. That's nice.
That's our little chime. Anytime we have a Latin phrase on the show, we're going to have that.
We could have a whole. I could do an episode. I might be by myself about the importance of the Latin language to modern legal practice, to learning other languages, to speaking English, being an all-around decent citizen. So I think maybe that's what's. If there's anything where we're lacking in civics, maybe we need to start with everybody isn't taking Latin.
All right.
And go from there.
Well,
I'm sure people will jump on that in a hurry.
I took 3 years of Latin.
It's foundational. So
Yeah.
And now what we do is we shorten it to this, and we make a cause of action out of it. So
So-
the False Claims Act.
Tell us what the translation of that phrase is.
So it means for one who sues in the matter for the king as well as for himself. And basically what it came down is the king can't enforce all the laws. We're back to jolly old England. So he would allow others to do it in his behalf. And the person is not suing for a wrong done to them. They're suing for a wrong done to the sovereign. What we're going to talk about has a lot to do with fraud type claims. So it's like that. Somebody defrauds the sovereign, and the sovereign isn't aware of all the fraud, but if a person becomes aware of it, they have the right through this Qui Tam principle to go and file a lawsuit on behalf of the king, and then as a reward, sort of a letter of marque, and then they get a reward out of the bounty, whatever they recover on behalf of the king, they get a share of that. And because America, we adopted a form of that, and it's been around in different forms throughout history, but now is manifested, as Paul said, in the modern False Claims Act.
All right.
Yeah, the False Claims Act been around for a long time, though. I mean, it maybe changed some, but
That's right.
it goes back. I mean, back to the Civil War era, doesn't it?
Yeah, I think it really came out of Reconstruction era work with the government was
Yeah.
funding projects, and then
Yeah.
folks were not doing what they were contracted for, and then they were saying, we got to address this, and one way we're going to do that is we're going to invoke this ancient common law principle and put it into a statute and call it the False Claims Act.
All right, so let's talk about what most people would recognize as it is. This is a whistleblower action.
Yeah, exactly.
This is, you work for somebody who is defrauding the government, and you blow the whistle on them. And in doing that, if the government or you privately are able to successfully prove that who you're working for, whoever you're with, about, is defrauding the government, then you get a portion of what's recovered back from them.
That's right. There are a couple of important kind of broad categories of false claims cases, and there are defenses. But one of the first things you got to think about with a False Claims Act case is you don't just get to sue because you become aware of fraud. You have to be a whistleblower. You have to be a person who learned. You have to be the person who learned about it. So it can't be something that you read about on the news. There's something called the public disclosure bar, unless the reason the news learned about it was because of you. And depending on your level of access to the information and how you came about the information depends on how much you recover. So if you were the reason the news found out about it, I think you get like 10% of the recovery. But if you were the person who found out about it, then you filed suit and news never found out about it until after the lawsuit, then you get the fuller recovery. And there are some things that happen. We should probably talk a little bit about the mechanics of that. What happens if you think that you've identified fraud in a government contract or in a relationship with the government? What happens then when you find a lawyer? You call a lawyer, and then what happens?
All right, so let's take it step by step, okay? So I'm working at a doctor's office. Or a hospital.
Let me give you a real world example.
Okay.
This case just settled in the last few months. Walgreens just settled with the federal government, Qui Tam action for $106 million, I believe. And the allegation or the claim in that case was that Walgreens was collecting money from Medicare and federal health funds for prescriptions that they processed, but were never picked up by the customers. Mm-hmm. But Walgreens was still charging for them and getting paid for those prescriptions by Medicare. So someone at Walgreens did what? They saw, hey, there's these prescriptions that aren't being picked up, but we're getting paid for them. That is a payment that the federal government shouldn't be making. It's a false claim, false payment. And so they went and got a lawyer.
So at that point, you've identified some type of false claim. And Paul, as you're saying, what the process is, you've got this fraud. The government entity that's being defrauded is Medicare or Medicaid. And thank you, Paul. The next step, called the lawyer, you file a complaint, but you don't file it like you file other complaints. Qui Tam actions are filed under seal to begin with. And that's where the real fun starts. Explain under seal. So if it's under seal, it means that it's not public. So it's filed, sealed up, and actually it's not even served on the other side. So in this case, if a complaint was filed against Walgreens, it was not initially filed against Walgreens and served on them. It was named Walgreens as the alleged defrauder, but it went under seal and then was then served on the United States. So you have to let the United States know you're doing this, and then the United States takes that, reviews it in that under seal process, and then makes a decision about whether they want to get involved or not, which is, again, another important point in the lawsuit where you find out as what we call the relator, or the person that's relating the information about the fraud. Now, before we get to that, for those who aren't familiar with lawsuits too much, when somebody files a lawsuit, that's usually part of the public domain. Like you can pull it up, and you're sitting there at your house on you can pull it up on your computer right now, and it is the crucial final step of initiating a lawsuit to serve it personally on the defendant.
Give them a copy of it.
That's right. It's called serving process, and the process is the complaint and a summons that says you're now under the jurisdiction of the court. You got to respond. It is really, really rare for a case not to be public and for it not to be served on the defendant. Right. Yeah. So this is a really strange process under the law. It really is. And the one thing that gets frustrating about it to a lot of folks is how long it remains under seal. Yeah. And so maybe a little, this is an inside baseball, but the government has a lot going on, and these cases are assigned to the local U.S. Attorney's office wherever the complaint is being filed.
So you've got those government lawyers that get a lot of these cases filed, and they take a long time to review sometimes. So you've got to hire someone or use your internal investigative resources to look into it. And each agency, especially these ones like Medicare and Medicaid that we're talking about, have whole departments and investigating agents dedicated just to this.
Right.
The other thing that can happen is the government doesn't need a relator to sue on one of these things. The government can actually bring its own case for fraud, but much more often it's happening this way because of the.
And they have investigative teams like for Medicare fraud that like investigate this.
That's
stuff.
right. Yeah, on a regular basis. And if they find it and it's big enough, and they'll file suit. But if they find it, depending on the nature of it, they may take a lesser action. But what we're talking about here is when an employee of a company like Walgreens finds out about something like this, where there's fraud against the government and wants to report that, this Qui Tam gives them the chance to do that and then to potentially get rewarded for that.
Okay, so the Walgreens employee finds a private lawyer, finds Bowen Painter, right? We go down the courthouse and we file a complaint under seal, don't serve it. We take it to the government, to the U.S. Attorney's Office. What happens there?
The U.S. Attorney's Office reviews the complaint, the allegations. They do an investigation. Most often, they have 60 days to review the complaint,
Which never happens.
Well, they may review it, but after that, they typically just get extension after extension after extension, sometimes years and years to go through this.
And some of them are really complicated.
Some of them are very, very complicated.
Especially big ones.
Right. And it's fraud, so it's difficult to detect.
Right.
And the witnesses aren't that forthcoming. You're also trying to do an investigation against a company
Without them knowing.
Right. So that that requires a level of discretion and expertise. It does indeed take some time. But some of these cases do get some age on them, and there's really not a whole lot that the relator can do to speed that along, other than potentially talk to the U.S. Attorney's Office and try to move things.
Provide more information where they can, but
Right.
yeah.
And a lot of times, what happens when people think they've got a fraud, they're like, "Oh, I found it. I got some fraud. Who do I call?" You Google it. A lot of the firms that are doing this, they're really good at it. They do a lot of that. Sometimes a firm is really just looking for the cases that come through where they can make a quick claim, just wait for the government to do the work.
Mhm.
That's not necessarily a bad thing, but it does kind of create a business model where they aren't really invested in the claim. They're just hoping the government intervene, what we call intervenes.
Right.
So the decision that we're talking about, the U.S. Attorney's Office is looking at is, does the government get involved and take this thing over? Or do they say we're not getting involved and then the relator can do it if they want to or drop the complaint?
So the government gets involved. You've got the weight of the Justice Department. You've got the investigative arm of the FBI, or whatever
Yeah, the criminal
agency
investigative service,
is. Yeah.
whatever.
So I mean, you bring significant resources into a case that really no private firm could bring into it. So it's definitely easier on the lawyers, on the
Certainly.
representing the relator, if the government takes the ball and runs with it.
That's right.
And it's also always good news as the attorney for the relator if the government says, yeah, we want to take that case. Because, correct, generally that means the government agrees, yeah, this is a case. And not only is it a case, but it's one that we're going to use our resources to pursue.
Now,
There are a lot of cases that they will say, yeah, this is a case, but this isn't one we're interested in pursuing.
right. So there's different policies that are part of the Justice Department, whatever they're pursuing, that they're focused on one type of case over another.
That's exactly.
For right
That's a
now,
really
like
important
Medicare and healthcare, that's probably 90%, if not more, of what the Justice Department's doing. Is that
Absolutely.
fair?
Yeah.
So you've got
I
other
don't know about the
areas,
percentages, but it is
a lot. It's
taken.
a lot.
Yeah.
And so it's that's one of those things that if it's a Medicare type case, it's more likely that the government's going to get involved and take the reins than if you have a different type of case that maybe it is government funds that are being taken, but it's just not the focus of the Justice Department.
Well, I don't know what do you call it, a tangent or what, but maybe just talk about a couple of the different types of fraud. I mean, we talked about a very basic one where you've got, I wouldn't say basic, but kind of the standard.
More common.
You are presenting a claim as a person who says the government should pay me for this, for something that the government doesn't actually owe you money. You are saying pay for these prescriptions when those prescriptions have actually not been picked up, not being consumed by the intended person that the government is paying on behalf of. So that's what a lot of people think of. Then you have kickbacks. There's an anti-kickback regime where a provider gets some sort of benefit, and most of the time it's money, but it can be other things. Like vacations, trips, jewelry, nice bottles of whiskey.
Yeah. That's,
For
you to get providers say, "Oh, send your patients to my hospital,"
Right.
And I'll
So-
send you 4 roses.
or "I'll send you 4 rooms."
and whether they get 4 roses or they get 4 roses, it still can be a kickback.
Yeah. And you remember that there's a name for that law? What is it? I can't remember.
I think it's
The White Act.
The White Act.
The White Act.
In terms of medical,
Yeah.
like doctors
Okay.
referring patients to themselves is the White Act.
Yeah, that I don't know. I just know it as the anti-kickback.
We dealt with
statute.
that once before, and we've had one of these cases against a local hospital. That was a big part of it.
So that's one. Another one. This is more of a different context, but you have and think about military contractor, not just military, but just government contracts and generally that are not healthcare. So you've got obviously defense contracts,
Mhm.
but then you've got engineering contracts, training contracts. So there's a case right now that I was following for a little while that was scheduled for trial, and I'm not sure if it ended up going in July of this year. Was a government contractor training case. So this contractor was hired to provide training for security overseas, and the allegations by the relator were the training they're giving they're not trained. These individuals that are showing up to do these jobs are not trained to do these jobs, but they're still getting paid for trained individuals. So that's a false claim. The government actually did not intervene in that case, but the council and plaintiffs decided to move forward with it and went anyway and went through summary judgment. Judge Land denied summary judgment to the defendants on that case, and it was going for trial. So I have to look into where that's at when we do another episode, because that was an interesting one to me. One, the subject matter, it's not healthcare, it's defense contract, or I think this was the Department of State, but it's also what they call like a false certification, where you provide the government a good that you've agreed to provide them, in this case, trained people, but they're not quite as trained as they say you, or as you say they were, and then that's a false claim. And I like that because one, it's a little creative, but two, is an interesting question of like, what's the damage?
Mm-hmm.
So if you so say it's a security contract, and we're going to provide highly trained security officers at your embassy over in Kabul, and turns out these folks are not really trained. All they do is sit around and goof off, and then write their names on a piece of paper, and then that gets papered over, and that's what the training is. But it's not actually teaching them how to keep a place safe. Well, if nothing ever happens to you over there, the embassy doesn't get raided or the security doesn't fail, is the government actually injured to the point where there are any damages for the false claim act? I mean, what do you guys think about that?
Well, they're injured in that they're paying for a product that they're not receiving.
How do you value that though? I mean,
Well, whatever the cost of the training, and the pay for it. I mean, I think
Is
perhaps
it-
what they paid is at least what they should get back. There may not be additional damages. They're like liquidated damages, but it would be, but if you order something and you don't get it, should you have to pay for it?
But what if you order something, you get it, but it's just not as good as what you thought you were going to get? Is the damage what you
The
paid for the
difference?
product, or is it the difference?
But it depends on if you're the United States government who writes the law that says you do get paid for or paid back for anything that you pay under false pretenses.
Well, there's as I understand it, there's a split in authority on this right now, and it's kind of an open question. And it's come up, Andrew. We've talked about these housing cases,
Right.
where you get, these sort of big corporate landlord, maybe not even always big corporate landlords, but folks that are receiving some type of subsidization or
Right, under Section 8
Right.
or federal housing, they're getting funds to provide low-income housing. And part of the deal to get those funds is you're going to provide housing that meets certain requirements,
Right.
in terms of
cleanliness,
utilities available, safety,
right?
habitability. So that's a deal you make.
So if the government's say paying $2,000 a month for these, apartments, and turns out that they're rat infested, or not even rat infested, let's just say that there's, it's mildewy, the AC doesn't work as well, it's not really habitable, but the people can live there. It's just not a very pleasant place to live and violates all kinds of housing codes, but it's not condemned or uninhabitable. I think the damages should be the full $2,000 in rent that they paid, because if it's not that, you're creating a really perverse incentive where they can just
Yeah, I'll give you $100 back, and I saved $800.
exactly. So I don't know. That'd be my position, especially if I'm on the relator side and the United States side.
I agree with that, and I would think the contracts. studied those contracts, but I would think they would be written to it has to meet this standard or it's worth nothing. Like
Right.
it's either meets it or it's
As
the
a
contract's
condition
void.
of this contract,
Yeah.
it's going to be habitable
Yeah.
to this standard.
As a material condition of that this is it. And if you don't do this, you're in full breach.
Right.
And the False Claims Act also provides more than just compensatory damages, correct? Tell us about the damages.
So the damages are trebled,
Tripled.
and you get attorney's fees. So that's not technically a Latin word, I guess. Maybe it has a Latin root. So
Trebled.
trebled.
You should have it anyway.
Yes, that means whatever the fraud that you uncovered is, you multiply that times 3 plus the attorney's fees and costs and expenses. So enormous incentives when you do that.
Yeah.
It does depend. The amount that you recover as the relator will depend on what level of source you are. Were the original source, and it wasn't something that got out in the news before you brought the claim. And the U.S. Attorney's Office, did they intervene or not? They intervene, then you get less. If they don't intervene, you get more. And it makes sense because if they intervene, you don't have to do as much to bring the claim. But if they
Right.
don't, you got to carry the load.
So we've talked a lot, about a few different types of where it comes from, but it's any time the government pays for a good or service that it does not receive. They paid for it, somebody accepts it, and they don't get anything back, or it's the claim is false.
Right.
The claim of the government is false.
There's some level
And-
of fraud in the
Right.
provision
And,
of the
and so we
services.
said, like, what you see most of nowadays is Medicare. Obviously, the medical industrial complex is huge. There's so much money flowing out of Social Security, Medicare, that kind of stuff. But you also have obviously defense,
Right.
huge area there. Maybe you don't see as much of that because the defense contracts are what they are. They're not as individualized. With Medicare, you have so many individual doctors and pharmacies, hospitals, that kind of stuff that can do different things. But it could be anything. Like we've got some friends who have been very successful in claims against universities who take government grants and then don't do with the grant. Yeah, don't do the research. And so they take the money and it gets kind of reallocated and it's loosey goosey and they didn't make use of the grant. And those can be, $100 million claims,
right.
depending on the amount of the grant.
It's an enormous amount of money going into that research. And it's really important stuff. I mean, the high level policy for this is the government is spending taxpayer dollars.
Yeah.
And they want to make sure they're used the way that they were intended to use. The government is just too big to do that enforcement. So
As big as our government is, they cannot have eyeballs on every provider who they're paying under contract or
Right.
Medicare or what have you.
Right. So it really is good. It's one of those things that you're doing good for the taxpayer by prosecuting these claims because it does recover money for the government. Knowing this threat's out there prevents people from defrauding the government, which otherwise would be much easier.
So we've been talking about federal whistleblower claims,
Right.
But there's also in Georgia there's a state whistleblower statute,
Absolutely.
which is similar. It's not exactly the same, but it's very similar. So if somebody out there is aware of someone defrauding the state of Georgia,
Mhm.
you could be a whistleblower for that as well.
So you talk about Medicaid. That's something that Medicaid is a state
Right.
paid for thing. So
Right.
that would be something. But yeah, anything that the state of Georgia pays for, if they're the claims that are being made falsify, that it's there, and then the Attorney General's office can choose to get involved or not get involved.
Yeah, and as that one works, I believe you have to get permission from the AG
Yeah.
before you can bring that case. It's a little bit different procedure, and each one is a little bit like that. But it's one of those areas that I think is a little bit underserved, just because it doesn't get the same splash as the
Right.
federal False Claims Act.
Definitely a lot more federal False Claims Act than state False Claims.
Yeah, I think it's like anything in the law is you get a rut dug in that, and so a lot of people see it. That's why you get the folks that get these cases, then file the claims under seal and just wait. The government intervenes, then they hold on, and if they don't, they just dismiss the case. But for the folks that are out there, I mean, think if you work within the government or you work with a contractor that works for the government, you should be on the lookout for this. And all this PPP money that went out recently, just enormous fraud happening with that. And sometimes it happens at a level that the government may not be looking at, even though they're trying to track that fraud pretty closely. So the public really has an important role to play in this Qui Tam thing. So speaking of
Now-
splashes, Paul.
Yeah. It's not there have been some challenges to this recently, whether the Federal Tort Claims Act is constitutional. And there's a district court judge, a federal district court judge in the Middle District of Florida, Judge Catherine Mizell, who recently issued an order, 2 weeks ago, that held that the Federal Tort Claims Act was unconstitutional. Now, a district judge issuing that order, which is being appealed, has no presidential value right now, but she based it on Clarence Thomas's dissent in a recent Supreme
Court Justice.
Yeah, Supreme Court Justice Clarence Thomas dissent in a
From Savannah.
Pinpoint to be more area I used to drive through hauling shrimp as a young lad.
The case that he dissented on was Polanski versus Executive Health Resources from 2003, and he stated in his dissent that there's a substantial arguments that the Qui Tam device is
another raging debate.
Yes, is inconsistent with Article 2, and the private relators may not represent the interest of the United States in litigation. Now, this really hasn't taken a lot of traction, but now you get this is going to come up. Obviously, it already has in the Middle District of Florida, and we'll see where it lands with the 11th Circuit Court of Appeals, which is where it's being appealed, and if this issue makes it to the Supreme Court. So, this has been around a long time, but it's nothing is beyond change.
No,
leave it to Florida to upset the apple cart.
Well, so here's the talk a little bit about this. First of all, if this is upheld by the 11th Circuit on appeal, I'm going to predict right now that it's going to be taken by the Supreme Court. If the False Claims Act gets struck down,
it's huge.
There's a lot of things to talk about here. Everything from the way that this district court judge came about her ruling. It's not the first time we've seen this type of kind of ground shift in ruling at a district court level because they're following a dissenting opinion in a Supreme Court case.
Right.
And that is just kind of an interesting trend, I think, in the judges that are on here. And there are a lot of reasons for that. One, it's never too late to kind of reevaluate. Why do we do things the way we do? That's how we got America in a way. Why am I paying tax on this tea or whatever? It's, well, what if we could do it a different way? And all of a sudden, swim across the ocean and fight a war. And now here we are. So that is interesting about this. But the other thing is my understanding of the ruling, and I haven't read everything about it, is the ruling was that it's based on Article 2 of the U.S. Constitution, which has to do with the executive branch of the president. And it has to do with this kind of principle called the vesting clause, where Article 2 power is vested in one president. So just the president and the people that are the president, so the entire executive branch, are the ones who get to enforce the law. You can't outsource that to non-executive branch people.
That's the basis for the ruling.
That's my kind of understanding of it, or at least understanding of the recent criticism of this type of thing. And I think from,
even though that kind of thing is done all the time. It's any
Yes.
private contractor for the government is a non-executive.
That's a great point, actually. Yeah, no, would this end government contracting,
Yeah,
actually?
it should. If you can't do this, then you can't
hire somebody else. You can't hire anyone outside to do anything that the
Government should be doing.
Right, at least the executive
It's a
branch.
government function.
Now only Congress and the judiciary can have contractors. So.
Right.
Nobody can enforce it if there's fraud. That's the argument. And I'm not a person to say that this is wrong because it's a bad outcome, because the False Claims Act should be a good thing. I don't think that's the right way to go about a legal decision. If it's supported, but I think the problem is, one, this is it's a Latin principle. So it existed before this country did. And the False Claims Act was enacted in an era against a backdrop with that same common law history. And there was no indication that Congress was rejecting that or thought that there was an issue, as far as I can tell, about the constitutional infringement of this act on the executive power. It will be interesting to see, because what's going to come up is going to be this text, history, and tradition about, this originalist sort of thinking of, what was the meaning of the Constitution at the time, especially at the time of the enactment of the statute, but also at the time of the early colonial period when the Constitution was ratified. Was there really some sense that only the executive gets to do the executive things and nobody else does? I don't know. That's for the...
Well, we're at a time now, there's a lot of old law being reviewed. We just talked recently about sovereign immunity and how that's kind of, people are taking a new look at that and seeing whether it should, if it's gone too far, or whether it should exist at all in some cases. And so I think we're going to go into the next decade of an interesting time of reevaluating a lot of things that have seemed like they would never change.
Yeah, not a bad thing.
All right, guys, before we sign off, what starts with W, ends with T, and is a little funny in the middle?
What?
W-H-A, ha, in the middle, a little funny. T, what?
Point for Stephen.
And because everybody just cringed, that does it for another episode of Justice for Y'all. We'll see you next time.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.